All right, good morning. Please have a seat. All right, the last case for this morning is MCNAMARA versus MCNAMARA. Counsel, ready to proceed?
Yes, Your Honor. May it please the court, my name is Theodore R. Doran. I represent the appellant wife in this matter, Heidi MCNAMARA. And we have before you four issues, the first of which is arguably a case of, well, I think it is a case of first impression, at least for a Florida court. The question before the court this morning in this regard is what law applies for purposes of determining the enforceability of a prenuptial agreement when the parties have agreed to a foreign jurisdiction as the basis for that consideration. In the case at bar, we have a prenuptial agreement that was entered into in Georgia, and it was indicated that Georgia would be the law that would be applied. It is our position that it was inappropriate for the lower court to apply the Georgia law, and that in fact is what he did. What we know is that Florida, unlike Georgia, there's a confidential relationship between a husband and wife or a prospective husband and wife at the time they enter into one of these agreements. Now this agreement, as the court is well aware, effectively rewrites Chapter 61 for all intents and purposes if you so choose to. And we know that the Georgia courts would agree with our position and disagree with the lower tribunal in this matter. In the Shearer case, they held that it was a matter of public policy and that they would not apply, for instance, in the reverse, Florida law for purposes of determining the enforceability of a prenuptial agreement. So while that is just persuasive and not binding by any stretch of the imagination, the Georgia Supreme Court has held, and it is the law in Georgia, that these matters constitute a matter of public policy, and as this court determined even in this very same case, in the MCNAMARA case, which was a preliminary appeal during the course of the case, an issue was raised with regard to a provision of waiver of attorney's fees.
Now, are you arguing as a general principle of law that Florida law would control all prenups regardless of where they were entered into, or that there is some specific provision of this prenup that should be interpreted according to Florida law?
I'm arguing that it is a matter of public policy in the state of Florida, that we have a confidential relationship that completely collides with Georgia's law, which is that they treat it as a commercial transaction. In fact, they require due diligence. There's no requirement of good faith. And yes, I am arguing that for purposes of determining, not necessarily going beyond into the contractual provisions, but for the purposes of determining whether or not the circumstances surrounding the execution of the agreement were met, Florida law would apply in every instance. The confidential relationship would have to be considered by a Florida court in determining whether or not to uphold a prenuptial agreement, irrespective.
And why is that a matter of such import in the public policy of the state of Florida?
Well, first of all, as I mentioned before, you're talking about effectively rewriting Chapter 61.
Well, all prenups do that, and certainly there's nothing in the law of Florida that is adverse to prenuptial agreements.
No, I agree. Absolutely not.
And indeed, that's the whole concept of it, is that the parties don't want to rely upon the dissolution statute. They're going to resolve these matters for themselves, and there's nothing wrong with allowing them to do that in most cases.
Well, yes, that's absolutely correct, but the circumstances under which that document must, under Florida law, be executed, i.e., that there must be full and frank disclosure, that there must be a general or a general approximate knowledge.
The court found that there was full and frank disclosure. So
I'm sorry?
The trial court found that there was sufficient disclosure.
I don't need to interrupt, Your Honor, but in fact the court specifically found there was not full and frank disclosure, specifically ruling that only subparagraph B, and that's my next point if we move beyond, if Florida law is going to apply, then the important point for you all to understand here, because there's a lot of information, is these two facts.
Well, the trial court found that the wife had the general and approximate knowledge of the character and extent of the husband's assets at the time of the marriage. I mean, is there any dispute that, he disclosed he made about $145,000 a year and his assets are worth about $3.5 million?
Well, let me just, I will answer that specifically, but let's recognize the first step in this process, and the trial court found that the prenuptial agreement did not make a fair and reasonable provision for the wife, and how could it at $1,000 a month in alimony?
Do you agree that unfairness by itself under Florida law is not a basis to say?
Absolutely not, but it shifts the burden. And if you read the trial court's ruling, he did not shift the burden. What he did was go on and criticize the wife for not asking for an attorney, for not asking for more time, for not asking for more information. That is not the standard. The standard is the burden is on, in this case, the husband to produce this information. The court specifically found...
Did the trial court find that the wife had a general and approximate knowledge of the husband's income and assets?
Absolutely, and there is absolutely no record evidence to support it.
Did the husband testify? He told her this and that?
Well, only 2 hours before, arguably, she signed the agreement.
They were going back and forth on this for months. And indeed, the record evidence indicates that the wife had made certain changes to the proposals, that they went through 5 drafts of the prenups. And so your suggestion that this was the day before, 2 hours before the marriage, isn't persuasive.
Well, Your Honor, you need to please rethink that, because while you're correct about them considering drafts of the agreement, there is no record testimony whatsoever that any of that dealt with his financial circumstances. None of that was considered until 2 hours before, but for whatever she might have observed leading up to the execution of the agreement.
Right,
he
so
literally...
The court says, that there was no reason if she wanted additional time to review these documents that she couldn't have asked for. It's not like they had some formal wedding planned, which was observed by the trial court.
Well, they got married the very next day and flew to Paris. But again, it depends.
Any indication these documents weren't something that could be reviewed in 2 hours? If the question is, what's the extent of his assets? Does it take more than 2 hours to do that?
That's the question before you. Is that a knowing and informed understanding of the general and proximate nature of the husband's assets? If it is, then you need to rule against me.
And if she's got a week to look at it, it's okay, but if she's got 2 hours to look at it, it's
well,
not
by
okay.
his own admission, he had the same document 2 weeks earlier because he whited out the date and changed it forward to the day before, the day of the signing of the prenuptial agreement. So why is it that the husband just didn't give her the document 2 weeks before? It's a matter of gotcha. Now, if the ruling is going to be, rule against me, but you've got to say that it is okay for a husband to withhold the financial information right up to 24 hours before the execution.
Is that a question of law?
I'm sorry?
Is that a question of law?
That meaning yes. I mean, I think that it's, the Supreme Court has ruled that there must be a knowing and not an understanding, a knowledgeable understanding of what the husband's assets are. And I don't think you can do that in 2 hours, not being represented by counsel, him being represented by counsel in Atlanta.
You indicate in your brief that she didn't have the ability to get counsel. Can you explain that in light of the evidence that apparently she was paid $5,000 a month for doing nothing for his company?
Well, that's an interesting point in light of the fact that she only got $1,000 a month in the prenup, but yes, I'll explain it exactly. She got $5,000 a month for doing nothing. After taxes, she got $3,600. $1,800 of that, even according to the husband, was required to be spent on food and other responsibilities in the household. They started this matter in December, and so at most she would have had $3,600 if she didn't spend one penny leading up to. She would have only had $3,600 if she didn't spend one penny.
That's not enough to retain a lawyer to review a prenup?
Well, it is. I mean, it is, but you've got a husband who's got $3.5 million, you've got a girlfriend who is...
But it was then her choice not to retain counsel. It's not what you said in your brief that she didn't have the ability to retain counsel, correct? She apparently made a choice. She had other priorities she wanted to use her money for, but it's not that she didn't have the money to retain a lawyer, right?
I think it's arguable. I mean, $3,600 when that's all the money you have, I think it's arguable that that money obviously is going to be spent on other things as well. So, you know, did she have $500 or $600 to go hire a lawyer? Maybe. But he's represented by one of the, and this is not my characterization, he's represented by one of the top family law firms in Atlanta. Now, he stands by while he watches her, unrepresented, sign the prenuptial agreement, having only provided her the information 2 hours before that.
That she had been encouraged to seek independent counsel?
Yeah, that testimony is in the record. But he still stood by. He still watched it happen. He still knew that he had only given her the financial information.
He was supposed to say, stop, don't sign this. Whatever you do, don't sign this.
Absolutely not, Your Honor. You know what he's supposed to do? He's supposed to come to this woman 2 or 3 weeks in advance, maybe, and say, hey, here's the same information that he did give her 2 hours before the event. It already existed because by his own testimony, he redated it from 2 weeks before. He's supposed to say 2 weeks before, here is my financial information. He's supposed to say, if you don't have the money for an attorney, I will make sure that you understand what's going on here. That is the standard in the state of Florida.
But the time frame element is relevant to the coercive element, correct? You know, if you get told 2 hours before a wedding rather than 2 months, it's because it's more likely to be coercive if you know, the typical case where there's a big wedding, guests coming from out of town, family coming from out of town.
I understand that.
All right, in this case, the testimony is only going to be 3 people at the wedding, the presiding official, a witness, and a photographer.
No question about it.
So, no coercion there by Delane.
Okay, and I understand.
The testimony was that they were going to go to Paris regardless of whether they got married or not.
Yes, sir, I understand.
So where's the coercion?
Well, it doesn't have to be coercion. Coercion is...
The 24 hours that you're talking about, the 2 hours, whatever, all relates to coercion. But if there's no coercion, then what's the relevance of that time frame?
Completely under step 2 of the Casco. Step 1 is whether or not there's duress, overreaching, fraud, etc. That's what you're focused on. I'm focused on step number 2, which is totally a different track. And that is if there's unfair and unreasonable provision, which this trial court did find, then the burden shifts to the husband, and the burden he has to carry is that he has to establish that 1 of 2 things occurred. Full and frank disclosure, it did not occur. The trial court did rule specifically by omission, by specifically saying, I'm only going to rely on the general approximate knowledge. So now you've got, he has a burden, and it's general approximate knowledge. And what they rely on, look at their brief, the facts they rely on are general, candid conversations, the substance of which aren't even relayed in there. So you're down to...
If she had general and approximate knowledge of his financial situation prior to signing the agreement, why does it matter if it's 2 hours, 24 hours, or 2 weeks before if there's no coercive aspect of it?
Okay, well, because it has to be knowing. So if you're conceding, as I'm suggesting...
No, but she knows.
If you're conceding by your question, as I'm suggesting, that she did not know anything until 2 hours before, now, you know, keep in mind, the trial court tried to go under the Holocaust case. They say it's irrelevant, and the trial court nonetheless relied on the 4 factors that Holocaust said you cannot rely on in the second BCA. And I'm running out of time. I'll enunciate them if you want. But the point is, if you're conceding that it's only 2 hours before, then rule against me. If that is the law of this land, then let's say so. Let's say that you can walk in 2 hours before you sign a prenuptial agreement, slap down the financial affidavit, and say, now you know. Is that the law of this land? I say no.
What if she gets it 2 hours before and goes, this is exactly what you told me. Now, I want to get married today. And he says, well, I don't want to get married for a couple of weeks. She goes, I want to get married today. I mean, under your argument, 2 hours, prenup's no good.
My argument is that if the husband waits until 2 hours before the execution, he's wasting his time.
And if the husband comes in and says, here's the agreement, you can sign it now, but if you want to take 2 weeks, that's fine, and she says, no, I'd just soon sign it now, he's supposed to say, No, that's not fine. I'm overruling you. Take the 2 weeks. Is that what you're saying? He needs to do?
I don't know that those are the facts of this case. I don't know. Hypothetical, I don't know.
Right. That's why it's called a hypothetical.
Oh, well, that's not the facts of this case. I don't know. You know, I mean, you're under a lot of pressure, obviously. You're sitting there in front of his legal counsel. You're
under a lot of pressure if he comes in and says, here it is, if you want another 2 weeks to look at it, take it. Where's the pressure there?
Well, that's not the facts of this case. The facts are that they signed it.
The facts of this case that he said if she wanted more time, go ahead and take it. They didn't have to get married the next day. They'd go to Paris anyway, etc.
I don't recall. He may have said that may be in the record.
So where's the pressure?
The pressure is in sitting at an attorney's table, everybody understanding they're going to get married, and he walks in and plays gotcha. Are we going to reward him for having waited till 2 hours before the execution of this to turn over his financial information? If so, we practitioners need to know that.
Taking him up on his offer to look at it for the next 2 weeks?
You know, I mean, that was his testimony. That wasn't hers. I don't know. Nobody else supported that. I don't know. I don't think that's particularly persuasive myself.
Well, you have a little over 4 minutes left. Do you want to,
I'll save the 4 minutes.
May it please the Court, Your Honors. Unless the Court has any questions for me, we're going to rely upon the competent substantial evidence that Judge Breeze carefully weighed. If you had to read anything in this record, all you have to do is read his well-defined rulings that he issued each time he had to rule on this case. The first one having to do with the validity of the prenup was on October 4th, 2007. The second one was July 25th, 2008. And the third one was November 24th, 2009. If the Court has any questions, I'll be happy to respond. If
I
not,
would like you to address the issue about the set-offs or the credit that your client got for payments related to the New Smyrna home?
Yes, sir. The New Smyrna home was the, quote, marital home at the time of filing in November of 2005.
let me narrow it, you know, because I think that I'm on the same page as
Yes,
Mr.
sir.
Palmer on this. The prenup says that Mr. McNamara shall provide a marital home in which the parties shall reside, and he shall be responsible for the payment of all reasonable household and living expenses of the parties during the marriage. That seems to be unambiguous.
I agree.
And that he then is, under the terms of that provision, is responsible for payment of the household and living expenses, and yet he was given a set-off.
I'll explain why. What the agreement clearly provides, and you read it correctly, Your Honor, it says that Mr. McNamara shall provide a marital home in which the parties shall reside.
Well, it says during the marriage. It doesn't
Yes.
say, you know...
It contemplates, in clear, unambiguous terms, what we presented to Judge Breeze, and what he found was that the agreement said not only would he provide a marital home, but it contemplated the parties would reside there. Now, what the evidence was, and it was unrebutted by the wife, that she told him in November of 2005, when she filed this divorce, get out, leave, I don't want you here at this marital home that we just spent $600,000, $800,000 refurbishing. I want you gone.
Does that make it no longer the marital home as of that point in time?
That was our position with the trial court. The trial court heard...
Do you have any case authority for the proposition that the marital home ceases to be the marital home when somebody leaves the home?
When someone asks them to leave it, Your Honor, I don't have a case. I just know that that's what I refer to as the former
Most
marital
final judgments say there's marital property, there's the marital home, it's worth X dollars, right? It doesn't say as of the time of the trial, there's not a marital home because only one person's living in it,
Most
right?
final judgments and this one talk about marital property. It was marital property because it was put in joint names.
So it was marital property, but it was no longer the marital home? Is that your distinction?
Yes, sir.
And was marital home defined in this prenuptial agreement?
No, sir.
Anyway?
Not other than the marital home in which the parties shall reside. And Judge Breeze heard testimony from Mr. McNamara on that, and that she told him to leave, and that he no longer lived there. It was no longer the marital home. Ms. McNamara never
Their
testified.
argument isn't so much the definition of marital home, it's the section that says in which the party shall reside.
That's correct. And also, importantly, that the court heard testimony on that exact subject and this provision from Mr. McNamara, and there was never any recalling of Mrs. McNamara to the stand. She never controverted that and said, no, it was still remained the marital home. I didn't ask him to leave. None of that.
Well,
There was
except
no
for your
testimony.
argument as to how that provision should be read, it doesn't matter if she asked him to leave or not. Under your argument, if sometime during the marriage, say 5 years before, he left the home for 2 months, it wouldn't be a marital home in which the parties resided.
If
Would
he
he be
temporarily-
able to get credit for the 2 months he left 5 years before?
Of course not, Judge Vander. If it's
Okay,
a temporary
well, then-
abandonment,
right, but-
or temporary leaving is not discontinuing the former marital
You're
home.
asking us to read this, that if he's not living there, if he's chosen, or if he's been asked to leave there, that it's no longer the marital home,
No.
which...
I'm just asking you not to reweigh what Judge Breeze already determined from the undisputed evidence.
Well, we can read the
Yeah,
contract
right.
the same way as he can.
Exactly. It's a matter of interpretation of the
Except there is
agreement,
some-
which is a contract, and that's a de novo review.
Except for the evidence on this subject matter and the fact that, unlike the hypothetical posed by Judge Vander, he never returned to that home. He's not at that home today.
In your theory, under your argument, it wouldn't matter whether she threw him out or he left voluntarily, right? If he had decided just to leave, he wants a divorce, the day he walks out the door, it's no longer covered by the
No,
agreement,
sir. I
correct?
think there's a distinction that was made in the evidence that we adduced, and that was that she requested, she instructed him.
Why
to
is
leave.
that relevant under the language of the contract?
Because she elected it. It was her election, and it was in that
Why is that
provision.
relevant if the contract says his obligation is based on a home in which they reside together? Under either of these scenarios, they are no longer residing together.
Because that was a provision that was designed to protect her and provide a benefit to her, and she had the right, if she chose to do so, to elect to terminate that benefit, and that's what she did.
If she terminates the benefit, as you call it, by moving out, she moves out.
That would be one.
The parties are no longer residing together. Would then there be any entitlement for a set-off or half? The general rule being that each party's liable for the responsibility for the expenses. Would she then have been liable for half of the expenses?
I don't know, because that didn't occur. She didn't move out. She chose to elect.
But we're trying to examine the logic of your reading of that contract.
Had she could have elected to move out and deny herself the benefit of a marital home. She could have elected to continue to reside together in the marital home. There's no evidence of domestic violence here. She didn't have to instruct him to leave. This is a large beach home on New Simona Beach. There's more than one bedroom. They could have peacefully cohabitated there, and no one would have had a credit. They would have continued to live there, and he would not have had to go try to live back in a home that hadn't sold in Atlanta, or part-time in a vacation home in North Carolina, or as he actually did in the testimony submitted, live in the home here in Orlando with his dying father.
Now, for reading this provision,
Yes.
husband shall provide a marital home. So are you agreeing or disagreeing that this resident stayed a marital home even after he moved out?
After she told him and she elected to tell him to leave, it was no longer a marital home. He supplied a marital home from February 13th or February 14th, 1992 when they got married, up until I think it was November 29th when he was told to leave. Any other questions by the court? Thank you, Your Honors.
Well, obviously, I'll confine my comments to the issues that the court addressed with Mr. Young. I understand he's advocating, but I think that what he's suggesting is quite a stretch and probably, based on the questions that the court asked, doesn't comport with logic. First of all, I would say Mr. McNamara's a big boy, and nobody made him go. There is no court order that said he had to go. Because she asked him to go, and he chose to go, I don't think it vitiates his responsibilities to provide for her under the contract. This is an example of what we referred to where, in our view, Mr. McNamara wants all the benefits of the equitable remedies, but he doesn't want, and at the same time, he wants the benefits of the legal remedies under the contract. Well, if the contract is the contract, then let's read it and apply it. And clearly what it says is he's to provide her with that home. So this credit that he's been awarded is not right. It's a violation of the agreement. It's maybe a nice equitable thought, but if that's the standard, then that means that the contract doesn't exist and we move on. Don't lose sight, too, of the trade winds issue. I mean, there's the same issue. Contract says what it says. They had joint property. Everybody agrees it's unrefuted. They sold the property, and all the cash went into the total control possession of Mr. McNamara, where he dispersed it when he wanted to, and he testified that she had no say over it. Now, that's $375,000, I think. It's in the brief that he took from her, and that needs.
Didn't it all go into the New Smyrna house?
It doesn't matter what it went. That
wasn't my question. My question is, didn't it all go into the New Smyrna house?
No, it did not all go into the New Smyrna house. Some of it did, but it doesn't matter. Because that's the whole purpose behind the prenup. If we're not going to have a prenup, then it matters. But if the contract says that whatever is in my name is what I spend, and whatever is in your name you spend, and jointly we both own it, if that is what the contract is, then it doesn't, once he took that asset away from her, took it away from her possession and control, and then spent it, it doesn't matter what he spent it on. He could have bought her a diamond ring. It doesn't matter. He should not and could not have taken that asset away from her. And also, it hasn't been mentioned, but we do have the retroactivity issue, which I think is probably fairly straightforward. We would ask the court consider that issue as well.
Thank you.
Your Honor, may I respond fully to the trade winds issue?
No, Mr. Young, you had your opportunity to address.
Right, thank you.
We'll be in recess.